Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, we are a couple of weeks into the publication of the pistol brace rule. I personally am going to wait about 30 days before I decide to do anything. And the reason is because I have a feeling, and I bet you do too, that a lot of lawsuits may be coming. Now, we've already done this video right here where we did talk about the first lawsuit. And I said there, hey, this is the first of what I anticipate will be many. Well, guess what? We have the second lawsuit filed, and I figured this would be a good opportunity to get you up to speed because I've had a chance to read the pleadings, and they are really, really well done. So today, let's get you all educated on, here comes the second lawsuit to stop ATF's pistol brace rule. Okay, so the case I'm talking about today is a case called Britto versus Bureau of Alcohol, Tobacco, and Firearms. It, too, shockingly, is filed in the Northern District of Texas. Seeing a trend here. This one in the Amarillo Division. Now, all three plaintiffs, Mr. Britto and two other named plaintiffs, are all former United States Marines. They served valiantly in their country. At least one of them has been wounded previously, not in combat, but actually got shot up in Minnesota and is partially disabled and uses pistol braces for their design purpose to stabilize one-handed shooting. The pleadings on behalf of the plaintiffs here are asking for a temporary injunction on this implementation of the rule or the enforcement of the rule. Now, let us all remember that a temporary injunction is based on a two-part test, and if granted, is always positive signs for the plaintiff. Number one, the plaintiff must prove that there's irreparable harm. That is, that there is harm that's about to be incurred by me, the plaintiff, and unless we stop this, this is harm that cannot be fixed. The second thing, and this is really the more important thing in a lot of ways, is the plaintiffs must demonstrate that they are likely to prevail on the arguments on the merits of the case, which means you got to show that, hey, you're probably on the right side of the law. Now, as I mentioned earlier, I think the pleadings are really, really well crafted. This is some of the better pleadings I've ever seen. And what I like about it is I think they've got all the bases covered. And for the first time since a case came out, this case right here, we are actually beginning to see that cited. And that is a case that I've been beating that drum on since it came out. Everyone keeps talking about the Bruin case from last summer, and I'm telling you, the West Virginia versus EPA case could have a devastating impact on the ATF. Let's get through the pleadings. Okay, so one of the things that the United States government relied on is a case called United States v. Cox. It's a case that involved an old two-part analysis, and they were like, hey, listen, we've always been able to regulate short-barreled rifles and short-barreled shotguns, and so therefore Cox is still good law. Now, that was decided pre-Bruin, and of course the plaintiffs' attorneys were very quick to point out the following. Finally, Cox contended that short-barrel rifles were dangerous and unusual under DC v. Heller. That is true only as far as it goes, but pistols with stabilizing braces are not unusual, they are ubiquitous. Indeed, ATF believes that there are around 3 million stabilizing braces. The Congressional Research Service estimates that there are up to 40 million stabilizing braces. In contrast, according to ATF, there are only 460,544 NFA-regulated short-barrel rifles in America, less than 2% of the number of pistols with stabilizing braces using Congress's estimates. And stabilizing braces certainly are not dangerous, as the entire purpose of the brace is to make the gun more accurate and therefore safer. And so you can see one of the arguments is that the government's trying to say, hey, listen, these SBRs are dangerous and unusual. And if we take a look at the common use test in Heller versus District of Columbia, which we talked about in this video right here, there is a historical tradition of government being able to regulate firearms which are dangerous and unusual. The problem here for the government, and their argument will fall apart, is that there is nothing unusual about a firearm that probably there's 40 million in circulation. Okay, then in addition to that, we're arguing, of course, the separation of powers, because everything that the ATF does is a violation of the separation of powers. But this time, plaintiffs' counsel got it really right, because not only did they quote from Justice Thurgood Marshall, probably not the most pro-Second Amendment judge to ever come along in the Supreme Court, but even Justice Marshall had pointed out, the provision mandates that important subjects must be entirely regulated by the legislature itself even if Congress may leave the executive to act under such general provisions to fill up the details. But in addition to that, and I'm going to give a huge bravo and kudos to plaintiffs' counsel here, the West Virginia versus EPA case is very correctly brought up and very correctly used, because this is how plaintiffs' counsel references that. The major questions doctrine, or clear statement rule, provides a check on agencies asserting highly consequential power beyond what Congress could reasonably be understood to have granted. In West Virginia versus EPA, the Supreme Court explained that Congress must speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. So as you can see, we are finally beginning to implement the important holdings of West Virginia versus EPA, because if you really truly want to understand where the lines are, where the lanes are divided that keeps each branch of government in its corrective lane, it is West Virginia versus EPA. So it is a very proper and intelligent attack by plaintiffs' counsel. Now, in addition to that, in addition to the Bruin and Cox analysis that we've already talked about, in addition to the separation of powers, plaintiffs' counsel is also pointing out that the new rule now actually conflicts with the federal statutory definition of rifle and short-barreled rifle. This creates all sorts of problems, as plaintiffs' counsel put it. The rule is unlawful because it amends the definition of a rifle in a way that conflicts with the statute's plain language. Our first step in interpreting a statute is to determine whether the language at issue has a plain and unambiguous meaning with regard to a particular dispute in the case. Our inquiry then must cease if the statutory language is unambiguous and the statutory scheme is coherent and consistent. So as you can see here, what plaintiffs' counsel is arguing is hey, listen, there is no reason for this agency to act to define something that doesn't need any further definition. Because when we look at a statute, and this is basic, you learn this the first week you're in law school, when the plain language of the statute is clear, we don't have to go looking at anything else. And fortunately, the definition of rifle used to be, at least to all of us, very clear. Now, one of the other things that the government typically likes to argue is the Chevron deference. Now, this is from a civil case, and it basically says, listen, when we have a large regulatory scheme and we have an agency that oversees this large regulatory scheme, we will often defer to them for interpretation of terms. The problem for the government here is that Chevron deference works really, really well when we're trying to assess the Chevron oil company with a $5 billion fine, or the FCC is trying to fine Fox News or something like that. But when we are actually turning people into criminals, you see the Chevron deference is not permitted. This is how plaintiffs' counsel correctly pointed out the law. But perhaps more importantly, courts do not defer to regulations interpreting a statute which imposes criminal penalties, such as here. And so what plaintiffs' counsel is pointing out here is we don't get to use the Chevron deference because we're talking about putting people in prison here. In fact, there's something else at play, and that's called the rule of lenity. Because you see, if the Department of Justice is arguing that, hey, you know what, the definition of rifle is still vague, and therefore we need to further define it. Okay, even if you accept that in arguendo as being true here, then when a statute is subject to two reasonable interpretations, but there is a criminal penalty at stake, the rule of lenity takes over, not the Chevron deference. And the rule of lenity says that we will adopt the interpretation as offered by the defendant. We always interpret in favor of less criminal punishment than we interpret in favor of additional criminal punishment. And then finally, to make sure we have a complete sweep of everything that's wrong with the pistol brace rule, there are significant attacks made under the Administrative Procedure Act, namely that the rule is arbitrary and capricious and void for vagueness, both of which are excellent arguments, both of which happen to be legally true. Okay, so once again, the case is Britto versus Bureau of Alcohol, Tobacco, and Firearms. We will put a link for the court listener docket down below so you can read the pleadings yourself. Now, for many of you who are sitting around waiting, what do I do during this 120-day period? This is the exact reason why I personally am waiting at least 30 to 45 days before I decide what I'm going to do with this amnesty registration. There are going to be significant lawsuits dropping. There's already a couple, and we've covered these two right here. We know that there are motions for injunctions coming, and there's going to be a lot of litigation ahead. I believe 30, 45 days into the publication of this rule, the legal landscape is going to look a lot different than it does right now. But in the meantime, if you have any questions about the pistol brace rule or anything else what's left of our Second Amendment rights, you guys should know the drill by now. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.